As we have 50 plus participants with us and they continue joining, so maybe a few more seconds. Okay, well, maybe I suggest we start. Ladies and gentlemen, and everyone in between, thank you for joining our discussion today, which is dedicated to the Special Tribunal on the Crime of Aggression against Ukraine. We will take a stock of the latest developments and we'll look into the future with regard to the establishment of the tribunal. I would like to remind everyone that our event today was co-organized by the Ukrainian Bar Association, Ukrainian Bar Association's Human Rights Institute, as well as International Bar Association, New York State Bar Association, and in particular its international section, Global Accountability Network, Raoul Wallenberg Center for Human Rights, and Robert H. Jackson Center. We have outstanding speakers with us today, and I would like to start by inviting Mykola Stetsenko, president of the Ukrainian Bar Association and managing partner at Avalon, to say a few opening remarks.
Thank you, Ina. Well, ladies and gentlemen, distinguished guests, colleagues, and friends, it is an honor to welcome you to today's event organized by the Ukrainian Bar Association, jointly with the Global Accountability Network, International Bar Association, International Section of the New York State Bar Association, Raoul Wallenberg Center for Human Rights, and Robert H. Jackson Center. I would like to first thank our partners for supporting today's webinar and more generally supporting one of the most pressing legal and moral imperatives of our time, the establishment of the Special Tribunal for the Crime of Aggression against Ukraine. We convene here not only as legal professionals and scholars, but also as representatives of a global community committed to justice, accountability, and the rule of law. February 2025 will mark the third anniversary of the full-scale invasion of the Russian Federation into Ukraine. Despite the threat of this act of aggression poses to international peace and order, it remains unaddressed and unpunished. Over the past 3 years, efforts to establish the Special Tribunal have garnered support from key international institutions, including the European Union, the European Parliament, the Parliamentary Assembly of the Council of Europe, the Parliamentary Assembly of the OECD, and the NATO Parliamentary Assembly. Additional numerous states worldwide have endorsed this endeavor as well. Simultaneously, leading international associations such as the International Bar Association, the American Bar Association, the New York State Bar Association, and the New York City Bar, among others, have backed the establishment of the Special Tribunal. Naturally, the Ukrainian Bar Association has also made a statement in this regard. The core group of states, which includes now more than 40 states, came a long way since this establishment in 2023. Today, we hear that it is at the verge of establishing the tribunal, which makes our event even more timely and relevant. During our discussion, we would like to reiterate that the professional legal community and civil society organizations emphasize the importance of two critical aspects: a fully fledged international mandate for the tribunal, enabling it to deliver justice in the name of international peace and accountability. And second, the ability to lift personal and functional immunities for sitting heads of state and other high-ranking officials from aggressor states. These principles will ensure that the prosecution of Russia's top political and military leadership is as a matter of vital importance. No political or diplomatic considerations, no matter how significant, can justify a situation where Russian soldiers face punishment while their president, who planned and ordered this war, remains beyond prosecution. The moment a crime is committed, there must be a response. In Ukraine's case, that response is a clear and unequivocal commitment from governments, organizations, and nations. There will be a tribunal, there will be a trial, and justice will be served. I wish a productive exchange and thank you for being with us. Back to you, Ina.
Thank you, Mikola. And now I am pleased to invite Carlos Ramos Brosovsky, who is the chair of the international section of the New York State Bar Association. Carlos, the floor is yours.
Thank you very much, Ina. It's a great honor to be here briefly to represent the New York State Bar Association. And we are honored by our association with the Ukrainian Bar and with this program. We represent international practicing lawyers in New York and around the world. And I believe that all of our membership has the greatest admiration for the work of the Ukrainian Bar Association in these very difficult times. I think it's important to be humble about what a bar organization in the United States can do. We have certainly tried to do what we can, starting in February 2022, when we were one of the first professional legal organizations to condemn Russia's illegal invasion of Ukraine. As some of you know, we have set up a standing task force on Ukraine. We have sponsored trainings for Immigration Council, assisting Ukrainians coming to the United States, organized programs including in 2023 in Warsaw, on legal consequences of the war. And obviously, we look forward to continuing that engagement with the Ukraine Bar as long as it takes, and hopefully into better times. In the meanwhile, I would just note that this is a program about the legal consequences of war and the legal response to them. It's easy to see the geopolitical struggle, the struggle for survival that's reported every day in the news. I think it's important also to keep our focus on the fact that this is also a legal struggle for the most fundamental international law principles. And so I think we couldn't have a more distinguished panel to discuss the work of setting up the special tribunal. And as I said, in the New York State Bar Association, we're very proud to be associated with this work and support it, and wish you all a very constructive discussion.
Thank you, Carlos, and thank you for all your support. Now we move to the main part of the event, which is exchange of questions and answers. I am very pleased to introduce the outstanding panel we have today, and among the speakers we have Ambassador Anton Koronevich, Ambassador at Large of the Ministry of Foreign Affairs of Ukraine and also an agent of Ukraine before the International Court of Justice. We have Dr. Mark Ellis, Executive Director of the International Bar Association. We have with us Kirsty Sutherland, co-chair of the War Crimes Committee of the International Bar Association. Professor David Crane, former chief prosecutor for the Special Court for Sierra Leone and founder of the Global Accountability Network. We're honored to have with us Ambassador Hans Karel, former Undersecretary General for Legal Affairs and the Legal Council of the United Nations. Ambassador David Sheffer, who's the International Frankie Professor at quite a few universities around the world, and a senior fellow at Council of Foreign Relations. And finally, last but not least, Honorable Professor Irwin Kotler, International Chair of the Raoul Wallenberg Center for Human Rights and Emeritus Professor of Law at McGill University, former Minister of Justice and Attorney General of Canada, and longtime Member of Parliament, as well as an international human rights lawyer. Before we start, a few housekeeping remarks. I would like to invite our speakers today to be interactive, to jump on the questions that are of interest to you. If you would like to contribute to something other participants have mentioned, I would also like to invite all our participants today to ask your questions in the chat box. We will make sure we answer these questions to the best of our ability. And now to start, I am honored to invite Ambassador Koronevich to start our discussion. Ambassador Koronevich, we know there have been a few developments with regard to the establishment of the tribunal. Could you please recap those developments and share with us whatever you can share at this stage?
Thank you very much, Ms. Linova. Dear colleagues, dear participants, good afternoon from Kiev. It's a pleasure and honor, as always, to participate in the events organized by Ukrainian Bar Association together with partners worldwide, with IBA, with New York State Bar Association. And as Mr. President Mykola Statsenko mentioned, we are, of course, with the government of Ukraine members of the government. We are really grateful to our international community, to our expert community, to lawyers worldwide for support of many of Ukraine's endeavors and efforts, which relate to accountability and restoration of justice. So with this said, I may not exaggerate how important it is that the lawyers, professional organizations in Ukraine, internationally, in many regions of the world, support the efforts for accountability and justice for Ukraine. So thank you very much for this. And we are sure that with this support and with this assistance, notwithstanding all the difficulties and notwithstanding all the issues and elements which now arise due to the issue of justice, we will do the job and the justice will be restored. So in relation to one of the most important efforts and endeavors within this big, I would say, movement or big narrative of restoration of justice for Ukraine, which, as you are also aware, is part of Ukraine's President Volodymyr Zelensky peace formula, point 7. The establishment of the Special Tribunal for the crime of aggression against Ukraine is one of the key points, as we assure that in order to ensure accountability and restore justice, there must be accountability for the crime of aggression, because it is a crime of aggression where everything started. And any accountability would not be full, wouldn't be comprehensive without accountability for the crime of aggression. So that is why Ukraine's government, together with experts, with support of lawyers community and organizations, we work on this project, on this issue, to have the establishment of the Special Tribunal for the crime of aggression. The work has been going on for 3 years, with a core group of states being active for more than 2 years. And I think that now we are really on a very important moment in this story. So as you may also well be aware, there was a core group meeting lately in Brussels on the 3rd and 4th February this year, 2 full days meeting there in Brussels. And I think that there are some issues which are important to share, though some of them still are not yet for public discussions, but of course, we will be happy to share them as soon as there will be the understanding that it's possible. So first of all, it is understandable that the work of the core group should be finished in some moment in future, hopefully sooner than later. And that all the discussions within the core group, they should lead to a concrete result. That means that the result should be the concrete products, the drafts of papers, in particular the draft texts of bilateral agreement between Ukraine and the Council of Europe, enlarged partial agreement, and draft statute for the establishment of the Special Tribunal. This should be the work of the core group, which should be then form the basis for the establishment of the Special Tribunal. During this meeting in Brussels, there was also this very important public moment of public comments, in particular by the leadership of the European Union, by the leadership of the Council of Europe, that both our regional European leadership organizations, they mentioned that this issue of establishing the tribunal is one of the priorities, and both the EU and the Council of Europe support the effort, and they consider that during the meeting in Brussels and before it, a lot of important issues were discussed, which brings us to the very important point when we may move further with the establishment of the Special Tribunal. It is also very important that the leadership of the Council of Europe mentioned that it is important for the organization to see the establishment of the tribunal in 2025. So this means that hopefully and with due support and due assistance, the work of the core group may be finalized quite soon. And the possibility to see the establishment of a thing, of course, we're not talking about the launch of the work of the full mechanism, but establishment of the tribunal as it is, as international legal personality, may take place in 2025. And of course, we all on Ukraine's side, we all struggle to finish this job as soon as possible. In particular, we do see now the general architecture of the special tribunal, again, on the basis of these three main documents: the draft bilateral agreement between Ukraine and the Council of Europe, draft statute, and draft enlarged partial agreement. And we understand in principle what should be there, how it should be based. So now it's a matter of legal work to make it look as it should be appropriately in the final versions of the texts. We do believe that the framework of the Council of Europe and the basis for the tribunal in the form of the bilateral agreement of Ukraine and the Council of Europe gives us the legitimate and authoritative basis for the establishment of the tribunal, as it is the biggest European regional organization to which Ukraine is a member state, organization who has its aims, the justice, human rights, democracy, organization to which Russian Federation was a member before the full-scale invasion of Ukraine. So with all this said, we do think and we do feel that this is a good basis for us to move forward. We have future plans. We have already planned our future meetings of the core group. But again, I hope that this all work will be finalized soon. And a lot of the things we will be able to hear and to talk in public about. All in all, maybe to finish up this part, during last months, a lot of work has been done. In particular, during the autumn semester, I would say in 2024, with core group meetings in Vienna and Riga, with Vienna-Riga statement of the establishment of the special tribunal, which again underscored the need for the establishment of the special tribunal and the movement towards this aim, this goal. And I think the core group in Brussels just last week, it again underlined the unity of principles, the unity of value, and the understanding on which common legal grounds this work should be finalized. I mean, the work of the core group. So hopefully quite soon, we will be able to share some more concrete results of this work. I thank you very much for your attention.
Thank you, Ambassador Korunevich. I'm sure there will be questions that we will try to address. And in the meantime, I would like to invite Dr. Mark Ellis to share his thoughts on what a statute of the tribunal could look like and what, in your opinion, it should address.
Thanks, Ina, and thank you for inviting me. And we're delighted to be supporting this event. As you know, the IBA has been engaged with this topic since the start, and Ambassador Korunevich has kind of set out the what continues to be the roadmap, and we're at the end of that journey. So at least in the sense of structuring the tribunal, as he said, and so I'm very happy to hear that. Of course, the statute itself, to me, is kind of the critical component of this, because people will be looking at this, will be saying, well, what does this, how does this reflect in the ability to ensure that this tribunal succeeds? And so for me, I just wanted to for the audience and for all of us, the panel members, because it's not been made public yet, but I think we probably have a sense of what this statute might look like, and then to identify some of the key areas that I think are probably still going to be a bit controversial. I've always said, I think a number of us on this panel have also indicated the desire to ensure that this tribunal is really seen as an international tribunal. I think that's where it gets its legitimacy. That's will allow it to deal with some of the complex immunity issues that this tribunal will be facing. And so kind of ensuring that this is not seen as a tribunal that has been necessarily driven by Ukraine, although as we know, Ukraine has been a critical component, critical player of this. But what's happening in Ukraine is an issue for the international community, and ensuring that those who have committed the crime of aggression is a concern for the international community, not just for Ukraine. So I'm hoping that what this statute does is, first, it mirrors statutes of other international and ad hoc tribunals. We were on this long journey of international accountability, and we all know that we have experience with the previous and current tribunals. And so this progression of international accountability, I think should be reflected in the way the statute looks. So you're looking at a statute that again mirrors some of the experiences that we've had with other tribunals. To me, critical of this is going to be membership. As I said, this tribunal needs to be international. The statute, I think, needs to allow really broad international support. Even though the Council of Europe is creating it, I suspect that not all European states are going to see all the components in the tribunal in the same way. That, I think, is to be expected. But critically, I think providing a wider international participation is important, and Anton may be able to elaborate on that and where we stand on that with the core group on this. I think one of the other things that has come up over the past couple of years has been this critical issue of definition. How are we going to define the definition of the crime of aggression? I hope it mirrors the Rome Statute, 8 bis. We all know that Ukraine, under its Article 437, is also looking to create within its criminal code issues dealing with the crime of aggression that, again, mirrors the Rome Statute, and I think that's really positive. The other critical point, it was alluded to earlier, even before we got on to the event, about individual criminal responsibility. That's probably the most important issue here. We know that the crime of aggression is directed at individuals. We know exactly this tribunal's attention and where this is going to be directed. And I think, for me at least, it's critical, but that the status, the position of the person that the tribunal is focused on should not be prevented for the tribunal gain jurisdiction. I think that's really critical. And so, will this tribunal be able to pursue an indictment against a sitting head of state or any member of the Troika, not waiting for the individual to leave that office and focus on functional immunity, but on current personal immunity? Where does that stand? I think everyone will be looking closely at that issue as well. This relationship between Ukraine and this new court, in the sense of the primacy of this particular crime of aggression, I think will also be an important point. Something that I've not heard about discussed, but it certainly has come up over the years with the creation of the other tribunals, has been the issue of defense. We know that there's been critical deficiencies in previous tribunals. We know that this tribunal is somewhat unique because it will be targeting a much smaller group of individuals. But I'm hoping that this statute continues this path of ensuring that there's a defense office focused on the rights of defense. The fourth area, too, that has been discussed, and this will be interesting to see what this statute does on this, is, of course, trials in absentia. We know that these individuals at the highest level of Russian leadership, they're not going to be present in The Hague, in The Hague, where this tribunal is undoubtedly going to be formed. So the issue of whether or not the statute is going to provide trials in absentia, I know they're controversial, but they can be conducted consistent with international law, and I'll be eager to see how the statute deals with this as well. Kind of the other some of the other remarks that we'll have to look at is compensation. What does the statute do with compensation? And also, my last point, which this too has come up time and time again in the discussions of this tribunal, is the cooperation between this special tribunal and the ICC. That too has been debated. So for me, those are some of the key points that I think I certainly will be looking at to see what the statute, how the statute deals with these points. But again, as the ambassador said, it's been advanced so dramatically, and I think that's such a positive development. And the idea of getting this tribunal up and running this year is critical for many, many reasons. It's kind of long overdue, and we need to get moving on it. So that would be my remarks, Ina. Thank you.
Thank you, Dr. Ellis. I would like to make this question maybe a cross-cutting question for today's discussion. So hopefully we can contribute more and more substance to what the statute could look like, and maybe this is how our event could be practically useful. Now, I would like to invite Professor David Crane. We have mentioned, Mark mentioned legal precedents and existing tribunal. Could you please recap your experience with the existing tribunal, and also, given everything that has been done on the establishment of the Ukrainian tribunal, what are the chances, do you think, of successful, I would maybe split them, successful prosecution and a successful indictment and prosecution of the highest political and military leadership of the Russian Federation?
Well, thank you, Ina, and my compliments to our esteemed panel and friends. I think the first point I would make is we've done this before. We've done this successfully. We have taken down a sitting head of state. We've shown the world that using the rule of law is more powerful than the rule of the gun. So I think we should move into 2025 as we create this tribunal with confidence. Because again, the jurisprudence is on our side, the law is on our side, the facts are on our side. So again, with a proper plan, a strategic plan that allows us to move forward into creating this court, we can do it efficiently and effectively. And why do I know that? Because again, the international community came together. It was the United Nations as opposed to the Council of Europe. And Sierra Leone, Ukraine, came together, created a bilateral justice mechanism, and managed it to success. So we've got the precedent. I think this is really, really critical for our listeners, because I know our panel knows this, because several of them helped me create the special court for Sierra Leone. But the point being is that we tend to forget that the jurisprudence is on our side. We've done this before successfully. Everybody on this panel has been working on this issue since 2022. And it's been an important effort by many people, many nations, to come together to show the world that if a member state of the United Nations invades the sovereignty of another member state of the United Nations, they should be held accountable. We know that it's important, but of course the devil is in the details, but we've moved forward. I do want to point out that 2025 is the year. It has to happen in 2025. The future is a bit uncertain. And so we have to show also, and I think this is an important point for our discussion, and I'd love to hear my colleagues comment about this. We have to show that the international community has validity, has the ability to come together and to right a wrong. Because again, the whole idea of the 80-year paradigm of the United Nations is in question. And we have to show that countries, member states of the United Nations, can work together, come together, and face down legal challenges such as the aggression by the Russian Federation against Ukraine. So again, I really want to underscore that I move into 2025, and having been involved in this process with the colleagues on this panel, since 2022. I move into 2025 with some cautious optimism. I applaud the hard work of Ambassador Konevich and his team, as well as the core group, in moving forward with this. And it's been our honor and pleasure, many on this panel, to assist them where we can, and we'll continue to want to assist in this area. So I think that I think we have to have this panel. I mean, this court created in 2025. It has to have an appropriate, as Mark Ellis stated, it has to have a strong international backing. But again, as we move forward, we have to be confident in the fact that in reality, we can do this. And we also, and I think this is also important, is back when we were creating Yugoslavia and creating Rwanda and Sierra Leone and Cambodia and the International Criminal Court, we were just starting for the first time to do these things. But now we have the jurisprudence. We have the deep international experience of individuals who have done this before. And I think it's a critical element, and I really want to underscore this as well, is that the leadership of the court needs to be, and when we assisted in drafting one of the drafts of the statute that's being considered, we emphasized that the prosecutor, the registrar, the judges all should have been in that same position in another international tribunal. Why not? Because again, it's a critical trial, and it has to be done by people with the experience that they can bring and move this forward efficiently and effectively. And third, we have the proper rules of procedure and evidence that have withstood appellate scrutiny, and so that we can do this. And I think that this is really, really critical in our thinking and discussions this morning, but also as we move forward in creating this bilateral agreement and then the creation of the special tribunal. So those are some general thoughts, and I hope I've answered some of your question. Thank you, Ina.
Thank you, Professor Crane. We mentioned jurisdiction a little bit, and definitely it's one of the key questions for the tribunal and the statute. I would like to invite Ambassador Carrell to contribute to the discussion on the statute, but also maybe to share his thoughts about the legitimacy and jurisdiction of the tribunal, given that Russia is not a signatory of the Rome Statute and was expelled from the Council of Europe in September 2022, if I remember correctly. Ambassador Carrell, the floor is yours.
Thank you very much. I would like to emphasize the importance of the intervention of the earlier speakers here, and in particular, the responsibility of the, shall we say, Society of States around the world, that we have to act in a situation like this. And of course, I was involved in the establishment of the Yugoslav Tribunal, the Rwanda Tribunal, and the Cambodia chambers, and the courts of Sierra Leone. And also I was Kofi Annan's personal representative at the Rome Statute negotiations in Rome back in 1998. And one of my divisions was the secretariat of the Rome conference. I think it's extremely important that this effort becomes successful. And in a sense, I think it is sad that it was not possible to have a complete backing of the proposal that David Crane and Irvin Kotler and I and others have tabled here, which was based on the method that we used when we negotiated the chambers with Cambodia, because they turned to the General Assembly, not to the Security Council, because that's not possible in this case because of Russia's veto. But Sierra Leone turned to the Security Council, and I was asked by Kofi Annan to negotiate an agreement with Sierra Leone on that court. And I had excellent negotiations with Solomon Bareva, who was the Minister of Justice of Sierra Leone in those days. And this court became an excellent court. And they wanted to have an absolutely independent court in the Sierra Leone. And the interesting thing with this court is that before this court, a head of state was tried, Charles Taylor, And this is extremely important when you now consider how to establish the special court for Ukraine. Now, of course, it's very important, as many have said here, that there's a general support for this court. Somebody said bilateral agreement, an agreement between the Council of Europe and Ukraine. Well, of course, that is one solution. But the question is, should there be more states individually joining this court? This is a sensitive issue. But for me, the question of jurisdiction is extremely important. And I have a very special experience of this kind of work when I was a war crime saboteur in the former Yugoslavia. It was the CSE, the Conference on Security and Cooperation in Europe, who had asked us, the three rapporteurs, myself, and then my colleague in Vienna, legal advisor, and Gro Hillestad Thune of Norway. The three of us, we elaborated a proposal here. And we understood that the CSE could not establish and use legislation. So we looked at the national legislation of the former Yugoslavia. And there was nothing wrong with that legislation. So our proposal was that the sort that we proposed should apply the national law of the former Yugoslavia. But this is an extremely complex question. And when we made our proposal on the 9th of February 1993, the thing was that the Security Council had started looking at the same issue. So the CSE sent our proposal immediately to the United Nations. And then the Security Council took over and established, only a few days later, the Yugoslav Tribunal. So they used a different method, which they could, namely referring to certain international conventions and citing them in the statute. So I think it's very important to look at that statute when you consider the proposal here for Ukraine. Am I correct in understanding that Ukraine wishes to apply the national legislation in this court? Because that has a very special problem, because of the fact that national legislation is normally not valid when you come to sitting heads of states and people in this level, at the national level. So I think it's extremely important that you discuss very carefully how this court should be established and what law it should apply. And of course, since we now have the Rome Statute, I think the best solution would to have a clear reference to the provision in the Rome Statute, formulated in the same manner. That would help solve the problem. But as I said, since I have this responsibility of having negotiated both the Sierra Leone court and the special chambers in Cambodia, and then the experience from the Yugoslavia and the Rome Conference, I think we have to be very careful here so that we are certain that what we establish or what is established here by the negotiating parties here is fully, shall we say, competent and stable international court, because that is sufficient. That is absolutely necessary for a court of this kind, where the Troika may be those who will be held accountable for the crimes of aggression. So I can't stress more this fact that you have to be very careful, and I will be looking forward with great interest to see the text of the statute that is now being discussed. And I'm going to send to you in the UBA the proposal that we made back. It's 30 years old, but there's still general reasoning about applying national law in an international court. Thank you very much.
Thank you, Ambassador Karel. I think you put the question of today's discussion on the table, and I cannot but circle back to Ambassador Koronevich. Ambassador Koronevich, would you like to reflect on the jurisdiction and the functional immunity?
Yeah, thank you very much, Ambassador Karel. Thank you, Ms. Linova. Yeah, just very briefly, we believe that the tribunal should be able to apply international law and also national law if there is a need. So we do not think that there should be a tribunal which primarily or only uses national law. So this is not our main task. So again, let's see it all in package when it will be publicized. But we don't have this idea to make it work that the tribunal applies national law as a primary source. So international law should be there for sure, and we hope higher than other sources. Thank you. And of course, the statute and the rules of procedure as a primary source.
Thank you very much for that clarification.
Thank you indeed. A very, very useful clarification. Ambassador Sheffer, would you like to contribute to the discussion about a functional immunity and draft statute of the tribunal?
Well, thank you so much, Ina. And I have to just echo what all of my expert colleagues who we've been through such a long journey for the 3 years have said before me. I just want to tag on a few addendums to what has already been said. When some of us were involved in the preparation of the special or the statute of the Special Court for Sierra Leone, Article 6.2 of that statute was the basic exclusion of the immunity defense for heads of state and others of official capacity. The background context of Article 6.2 of the statute, however, as we were negotiating it and bringing it to fruition, was a lot of commentary, particularly at least from my neck of the woods in the United States, that the intention behind this court, the Special Court for Sierra Leone, was indeed to bring Charles Taylor, the leader of Liberia, into the jurisdiction of the court. We were very blunt about that. We were not saying that Charles Taylor had some sort of issue of not being within the jurisdiction of the court. We were proactively saying one of the purposes of this court is to it was to stimulate the investigation and possible prosecution of Charles Taylor. Now, you don't want to put that literally into the language of the statute, but I think that background noise is very, very important, particularly if the issue comes before the judges of the Special Tribunal for the Crime of Aggression against Ukraine. They might look back at the legislative history and some of the dynamics around the making of the Special Tribunal to understand whether or not the intention of the tribunal was indeed to include Mr. Putin, the Troika, etc., or were people sort of mysteriously silent about that issue because they couldn't quite figure it out. I do think there's value in there being kind of a political dynamic behind it to say, yes, this court is intended to cover those individuals. Now, at the, we leave it to the judges to reach that decision because, of course, defense counsel will bring that issue up and it'll have to be adjudicated. But I do think that background intent is important, particularly for the Ukrainian government to express, as well as some of the COE governments. Also, I want to just bring up the issue of what is so much in the news even today, which is the prospect of negotiations between Ukraine and Russia. I think it's going to be important to play this very, very carefully because you really don't want the Special Tribunal and the creation of it now, since we're at the cusp of it, to get entangled in the negotiations with respect to a peace settlement, because you know what the Russians will insist upon. They will insist upon the Ukrainian government standing down on entering into an agreement with the Council of Europe, or if they have already done so, to withdraw from that arrangement. They will insist on that. So I just would caution, it might be preferable in strategizing those negotiations to ensure that the international criminal justice and Ukrainian criminal justice issues are simply not on the table as part of the negotiations, because if you place them on the table in order to try to gain an advantage, to try to solidify something, the Russians are going to push back very hard. And you don't want to do that because that's going to jeopardize it. Justice can proceed on its own path, and it may take many years, but I'm very, very concerned that it get wrapped up in the negotiations, and thus all sorts of concessions then are invited in that process. And finally, I don't have the site in front of me, but a couple of years ago, I published an article in Just Security. This follows up on Dr. Ellis's point. I published an article in Just Security on how a special tribunal could, in fact, cooperate very constructively with the International Criminal Court in terms of how it organizes its investigative and prosecutorial work so as not to disadvantage the ICC, but at the same time keep the issue moving forward in the special tribunal. So I would just invite reference to that article of a couple of years ago in Just Security. And that's it.
Thank you, Ambassador Sheffer. You stirred the crowd. I see. Professor Crane.
I really appreciate the comments of my colleagues, and they're very, very important. I'm going to just kind of address a couple of these issues that are kind of sitting on the table now before us. You know, in the creation of the UN Special Court for Sierra Leone, we put in very wisely concurrent jurisdiction between the laws of the domestic law of Sierra Leone and international law. And we provided the core group of nations an example of that. We took it right out of the statute as far as concurrent jurisdiction, and I think that it can be done successfully. And when we're putting together the special tribunal on aggression, I want to address the important point that Dr. Ellis mentioned related to defense. You know, this court has to be seen as fair, open, and not a kangaroo court with an obvious conclusion. And that's one of the things that we had challenges in Sierra Leone to address. And one of the things that the registrar at the time when I was chief prosecutor in West Africa, the registrar and I sat down over lunch one day and said, you know, we have to show the people of Sierra Leone that the rule of law is more powerful than the rule of the gun. And we have to show that these individuals who we have now just indicted, they're going to be fairly represented. And so we created, well, he actually created, I couldn't do it as the prosecutor, but we kind of both agreed for him to create an Office of Public Defender. And so that we had a very vigorous office completely supported by the registrar, equally supported like the Office of the Prosecutor, to ensure that they have office space, equipment, some funding, vehicles, and ability to investigate and those kind of things. And it was a very successful effort related to ensuring that the defendants who have been charged with the world's most serious crimes are ably defended. And I think that that's kind of a success story. You know, Ambassador Sheffer brings up a good point about peace versus justice, justice versus peace. And it's always been there for all of us who have been around doing this business now, dare I say, 30 years. And so it is critical that we don't make justice a bargaining chip. And we have some examples, I think, really, that for us to show historical examples that it actually turned out that during peace processes, we had justice mechanisms being created and doing things, and it did not trip up a peace accord. And the first one that comes to mind was in West Africa. We had a civil war going on in Liberia at the time that I was in Freetown, right next door in Sierra Leone. And so all of the West African nations came together to try to come up with some kind of a peace arrangement. Well, their opening day, I publicly indicted President Charles Taylor as a political move on my part to get him out of the negotiations because he was very much disruptive and causing those problems. He was removed, literally went up the steps at 11 o'clock on the 3rd of June of 2002, I announced, as I was told, he was walking up the steps. I had a press conference. I held a press conference and unsealed the indictment against President Charles Taylor as a political act on my part to humble him and get him out of the peace process. 5 minutes later, he was trundled back down into his vehicle as an indicted war criminal, and a couple months later, he was removed from power. And those peace talks continued, and we still have a viable peace going on in Liberia. So that justice was not, in fact, causing the peace process to fall apart, but it actually enhanced the peace process. And of course, my colleagues, David Sheffer, Hans Corell, Erwin Kotler will certainly remember the days, and I'm sure Mark Ellis as well, during the Dayton discussions. We had Milosevic and our good friend, I think it was Louise Arbour, indicted Milosevic, and but yet the Dayton Accords continued to move forward. So again, good point, David Sheffer. Yes, we have to make sure that it's not a bargaining chip, but we do have historical examples where justice moved forward, and also peace was enhanced by using justice as a way of for stability. So anyway, I just wanted to make those comments. Thank you, Ina.
Thank you, David. Kirsty, please go ahead.
Thanks so much. I just wanted to address two things that have arisen. I think that on the defense, perfectly understood by the Ukrainian Bar Association. I think you guys have been making a lot of efforts to really ensure, to the extent that you're able to in the middle of a conflict, that there is a strong defense. Obviously, that's entirely essential to the legitimacy of any process. And I acted on the defense team for President Kenyatta, and then for indigent clients at the STL, the ECCC, and at the ICC. So I think that the kind of question of equality of arms is a very, very serious one for international courts generally, because it's just not met at all. Except I think in this situation, we'd be dealing with a high-ranking Russian government official. And I suspect in that situation, we could be confident that there would be a robust defense mounted with no expense spared. So that might not be too alarming in the scenario that you're describing. Moving on to the sort of question of immunities, I completely agree with what Ambassador Sheffer was saying about the importance of kind of overcoming this immunities issue. And I'm just sort of reflecting on how these are the most serious international crimes are by their nature state crimes. And I think that the international community might want to kind of reconsider its position on the customary principle of head of state immunity, just because of, I'm speaking from the position of someone who passionately believes in the laws of war and international law being respected. But I think on a practical level, the question or the challenge for this tribunal is going to be the number of states, especially in Europe and certainly in the US, who are going to be very, very sensitive about troika immunity. And I just wonder how, on a political level, that can be overcome. And to that, I defer to the expertise on this call, because I don't know the answer to that at all.
Thank you, Kirsty. I see a hand lifted by someone named Pour Le Gren. I'm not sure whether this is one of the participants. Our speakers, yes, please go ahead.
Yes, thank you. It's just to make the point that we cannot use the chat because it is inactivated, and you propose that we use it to share a question. So I just wanted to say that.
Thank you very much for letting us know, and I will ask my colleagues on the admin team to look into that. While we do that, I would like to invite Professor Kotler to share with us his thoughts on everything that has been discussed up to now, and also if the tribunal is successfully established, how long-term impact could it have on international law and global accountability for aggression? And do you think there are any challenges that we should envisage at this stage? stage already.
Thank you, Irina. And I begin by, at this point, by commending the Ukrainian Bar Association and its partners, where Raoul Wallenberg Center is happy to be one of them, for convening this timely and significant forum for all the reasons mentioned. I think it's important that we emphasize that the crime of aggression, as has been referenced, is not only the supreme international crime, not only the crime of crimes, but it is foundational. The combating of it is foundational to the pursuit of justice and accountability, anchored in the UN Charter and anchored as well in the foundational principles of the Rome Statute. We know, however, that the ICC does not have a jurisdiction. It has over the crime of aggression, but not over Russia, which is not a party to this statute. And more importantly, with regard to Russia, its conduct has been underpinned and incentivized by the crime of aggression. If we look back at the 21st century, began with Russia's invasion of Chechnya. It continued with its aggression in Georgia, continued with its seizure Crimea. And all this took place amidst a continuing culture of impunity. And so Putin could well have said to himself, well, look, I engaged in all these other acts of invasions, etc., and nothing was done. Why should anyone care if I invade Ukraine, where Ukraine is not an independent state, and Ukrainian people is not an independent people, and they're all part of Russia. So why should anyone object when they did not object before? I believe here the miscalculation occurred not because Putin miscalculated about the culture of impunity, which had incentivized his continuing aggression, but about the courage and commitment of the Ukrainian, yes, independent Ukrainian people and independent Ukrainian state, which was not a part of Russia as Putin had characterized it to be. Accordingly, the establishment of an international tribunal for the crime of aggression, and as you mentioned, Irina, in terms of the significant impacts here and lasting impacts, it will, first of all, not only combat the culture of impunity, but begin the process of securing justice for the victims and accountability for the crime of aggression and those who perpetrated this supreme international crime, thereby vindicating the validity of the UN Charter in which it is anchored, the ICC statute in which it is a foundational part, and the whole pursuit of international justice in that regard. Second, it will help to deter crimes of aggression, incentivized, as I mentioned, by Russia's continuing impunity for its continuing aggression. And so it will help to deter crimes of aggression, which regrettably have been incentivized by the impunity that has attached itself and has underpinned Russia's crime of aggression. We now have and live in a world of an increasing axis of aggression, involving also China, involving also Iran and the like. So this will help to deter the incentivizing crime of aggression, whether it be China, Taiwan, and the like. Third, it will underpin the principle that no state and no leader is above the law, that all are equal and accountable before the law, and that this is a foundational principle of the rule of law and international justice. Fourth, it will not only vindicate the actions of the core group, but let us not forget that some of the states at the core of the core group, I'm referring to those states, the Baltic states, Eastern Europe, and the like, are the primary prospective targets of any further aggression by Putin's Russia. So it will have a parallel deterrent effect in this regard. And fifth, and we should not forget this, it will help secure justice for the victims. And where the Special Tribunal will not only derive as well its jurisdiction from Ukraine, albeit important to emphasize what has been mentioned before, that this is an international tribunal, but in fact, Ukraine will be able to contribute the produce of its own investigations and prosecution, and refer that to the International Tribunal, just as the International Center for the Crime of Aggression at The Hague will also be able to contribute in that regard. And finally, the importance of the reaffirming the foundational principle that there can be no impunity for the crime of aggression, that the pursuit of justice is not only a foundational principle of international justice, but in this particular instance, foundational principle would be the crime of aggression in terms of the UN Charter, the ICC statute, and the like. And so, relatedly, having an international claims commission for the importance of compensation and reparations for the victims, and this can be built upon the registry of damages, which has an inventory and record of the destruction and damages that have taken place in Ukraine, that can all be brought forward with respect to the pursuit of justice for victims and accountability. At the same time, and this brings me, Irina, to the second issue that you referenced, and I will be brief on this. It does not mean that the establishment of such an international tribunal as we have been discussing is not without challenges. First, while the establishment of an international tribunal is not unprecedented, what is unprecedented, and Mark Ellis did not mention it in his remarks, but he has written about this and an important point. What is unprecedented is that this is the first time that an international tribunal focuses on a country with nuclear weapons and on a country with the geopolitical breadth and depth of a country like Russia. So this is the first geopolitical challenge. The second, again, Mark Ellis, I'll credit him with this, though we made this point elsewhere, but the point that he made recently as well in an interview, that some nations in the global south may regard this as a European tribunal and not as an international tribunal, which we have been emphasizing. It must be seen to be, as it is anchored in a global pursuit of justice by a global international tribunal, because we may see arguments that are brought up by some that why is Russia being singled out? Why is there a selective prosecution of Putin? And this we might find from the increasingly expanding BRICS coalition, some of whose countries want to themselves pursue acts of aggression, and therefore may seek to invert the agenda and try to make this tribunal to appear to be selective or European or prejudicial and the like, all the things that I think we can see forthcoming. A third challenge may be economic considerations, where some countries are economically dependent on Russia, and that may bring about their opposition. And finally, there will be the continuing legal challenges regarding head of state immunity, even if it is clarified in this international statute, but it can come even from within the G7. And in a Trumpian era, it can come increasingly from the United States, and that is something that we need to be aware of. So in conclusion, may I say that the crucial character of this international tribunal, as we have emphasized it in this panel and our work before, is that its establishment is a foundational, moral, legal, and international imperative of the pursuit of international justice, of combating the culture of impunity, of securing justice for the victims and accountability for the act of aggression. Thank you.
Thank you, Professor Kotler, for this wider picture, which is extremely relevant in this case. I see a few hands and a few questions in the chat. Before we proceed to them, I would like to reiterate once again that the chat now works. Thank you for for drawing our attention to this technical issue. Mark, please go ahead.
Well, I'm just going to take this time. I'm listening to Professor Kotler talk so passionately about this internationalization, this international focus, and you can't emphasize that enough. This is what this is about. This tribunal, if it's not going to be seen as international, if it's not the voice of the international community on the crime of aggression, then I'm not certain what we're doing here. So I don't want to put Anton, I don't want to put you on the spot on this, and I just want to say I don't know of anyone in Ukraine that has advocated more strongly for accountability than Ambassador Kornevich. He's just been remarkable, and he's seen that way internationally. So what has been dotted around in everyone's conversation has been what Professor Kotler just said about the international component of this. Anton, is it clear that the Council of Europe now will open this membership up to non-European countries to strengthen this sense that this is truly an international tribunal? That's question one. Question two, everyone has talked about this. This is the critical point. Are we leaning into a situation on the head of state immunity that actually this tribunal could suspend indictments filed by the prosecutor if in fact it deals with the head of state or head of government, foreign minister within the Troika, and wait until the tribunal focuses on the idea of functional immunity after the individual has left office? Because those 2 points to me are so critical, and I'm just wondering whether you think that there is leaning one way or the other in the discussions at the core group and within the council on those 2 critical issues. And I don't mean to put you on a spot. I was just curious whether or not do we have greater clarity on the head of state immunity debate, and do we have greater clarity on whether this is truly going to be an international tribunal inviting many states to join?
Ambassador Kornevich, would you like to reflect right away?
Yeah, thank you very much, Ms. Lenyova. Thank you very much, dear Mark, professors. It's really great questions, so thank you for them. If I may start with what Dr. Ellis suggested. So yes, of course, we do not foresee that any future special tribunal should be limited only to Ukraine and the Council of Europe as parties. So yes, we do foresee that it shall be based on the grounds of bilateral agreement between Ukraine and the Council of Europe, to which the statute should be an annex. But we do foresee that the mechanism of enlarged partial agreement, EPA, will let both Council of Europe member states and non-Council of Europe member states to participate in the work of the tribunal, so as members or associate members. So of course we do foresee that both European and non-European states should be able to do that. So in terms of international participation, I think that there are no things which divide us on the understanding of the need for this international participation. The same goes for defense office. So of course, there should be defense. This tribunal should incorporate all the best international criminal law standards. So of course, defense unit, defense office should be there. And of course, there is also the very important issue of victims, since the crime of aggression is a very special one. So who should be deemed as victims in this very essence? So these questions are also dealt with in terms of definition. Of course, I mean, Article 8 bis. So I may not go into details now, but the definition should again encompass the best international standards which we have currently in international law. The same goes for international representatives for key positions. We are absolutely fine with this. For the president of the tribunal, for judges in general, for the prosecutor, for the registrar. We do not foresee this as a Ukrainian effort. We do foresee this as international effort. I may not talk about the issue which I believe Professor, some of you professors and your excellencies raised about negotiations. As I'm work on legal issues, so I think I cannot comment on this today. And on the issue of immunities and troika, just very briefly, we are looking on this issue very carefully. So we of course understand that this should be a tribunal which is effective, if I may say so. I think as of now, I would limit my remarks here. Thank you.
Thank you. Ambassador Karel, would you like to contribute?
Thank you. When I asked the floor, I actually had the same questions that Mark Ellis put. So I have received the response to those. Could I just add one element, a very important element, reflecting on what Irving Kotler said, namely, we have now a permanent member of the United Nations Security Council, flagrantly violating the most fundamental provision in the UN Charter, namely Article 2, Paragraph 4, which forbids states to threaten or attack other states. This simply cannot be accepted, and this is why it's so important to establish a court in this case. Thank you.
Thank you, Ambassador Karel. Now I would like to move on to some questions from our audience. And the first one concerns the enforcement of decisions of the special court. There's even the problem with the enforcement of the ICC in a sense that it depends on the goodwill of states. Even signatories to the Rome Treaty can decide not to comply with arrest warrants, as Mongolia recently did. So I would like, in fact, ask all of our participants, are there any legal precedents that we can use, any best practices? And also, Ambassador Koronevich, I don't know whether this is something that the core group looks into. Professor Crane, please go ahead.
Well, thank you. We do have precedent. The UN Special Court for Sierra Leone obviously rendered judgments, convicted individuals, arrested individuals. And this is where, like I like to say, is where the bright red thread of a successful tribunal or court is politics with a small p. The enforcement is done by willing states who are agreed to actually enforce. And so our work in the Special Court for Sierra Leone, which would probably be very similar to a tribunal for Ukraine on aggression, is that signatory states would support, as well as just other states, on the fundamental issue of enforcing the rule of law. We had to go out and talk to other countries, negotiate with other countries, get agreements. But again, that happened. So that the precedent that because it was different than it was with Rwanda and Yugoslavia, which was in Article 7 ad hoc tribunals, and so all states had to theoretically do whatever they were asked related to whatever those issues may be, enforcement, arrests, what have you. Well, the Special Court for Sierra Leone was not created by Chapter 7. it was a bilateral agreement, as we've been discussing. So at the end of the day, it was basically the leadership of the court going out and traveling, and I traveled over 750,000 miles talking to various states, countries, members of those countries, senior members, talking to them about the importance of assisting the court in doing its job. And at the end of the day, we had very little pushback from any member state when they were reasonably asked for reasonable help. That state usually stepped up, to include incarceration of individuals who had been lawfully convicted. And that read that former President Charles Taylor. We had a successful negotiation with the United Kingdom, and that's where he's now spending the rest of his life in His Majesty's maximum security prison in the northeast of England somewhere. And so the bottom line is that we do have that precedent that a bilateral court, for lack of a better term, like Sierra Leone, like potentially this new court in Ukraine, just has the ability to go out and negotiate as a international body with states, supportive states, for whatever support that they can get, both from funding, sentencing, enforcement, arrest, etc. So there is a precedent.
Thank you, Professor Crane. Ambassador Kurunevich, is there anything you would like to add on the enforcement?
Yeah, thank you so much for this question. Of course, it is of biggest importance, because whatever the tribunal does shall be enforced. And of course, it should rely on cooperation of states. But for this, we need to have a strong cooperation regime. So yes, we are currently working on how to frame such a cooperation regime which would suffice all the needs the tribunal will have. So yes, this question is also in the loop, in the agenda within our current work. Thank you.
Thank you very much.
Ina, if I could just jump in real quickly. Also, something that we should consider, I know we had in the initial statute that many on this panel had put together to give to the core group, is potentially a management committee, which was also incredibly helpful as far as support to the court, because there was a group of a dozen states who were on the management committee, to include Sierra Leone, but in this case it would be Ukraine, where again issues such as support were also addressed to the management committee, who went out at the UN level and sought support as well. So just as a thought is that I think that we should consider a management committee made up of Council of Europe and other nations, core group, that would help manage the actual political support for this new tribunal, because it was a fairly successful effort in Sierra Leone. Thank you.
Thank you, Professor Crane. The question raised by Ambassador Sheffer seems to be particularly important and sensitive. How in practice can the court be protected from diplomats meddling because they strive to negotiate a peace agreement with Russia? Ambassador Sheffer, would you like to answer this question? And then if someone else would like to jump in.
Sure, I'll just provide a brief answer, which is, first of all, I completely subscribe to what my colleague David Crane said, that yes, it is possible during negotiations for justice to have a role in those negotiations. And we did that in the past with the former Yugoslavia. We did it with Rwanda, etc., because violence was still taking place in Rwanda even after the genocide. And it was also actually an issue with the Cambodia Tribunal because of the resilience of the Khmer Rouge that were still out there in the forests. But I would just say, in answer to the question that was raised, that I think there has to be a lot of strategizing that takes place by both the lawyers involved and the political people involved in any negotiating scenario, so that achieving justice does not become sort of entrapped in a political dynamic that then compromises justice. And that's going to be very tricky with Ukraine, particularly if there are opportunities for Ukraine to pursue justice where Russia could come in and say, no, actually, if you want your POWs back, if you want your forcibly displaced children back, etc., you need to concede sort of a zone of impunity for Russian soldiers and Russian officials, etc. I mean, there's going to be that give and take. And I'm simply suggesting that there might be great value in holding firm to a separate track of justice without complicating it with a negotiating scenario, with Russia. Because frankly, at the end of the day, what you want from Russia are the reparations. You want financial issues on the table to address, as well as the return of POWs, the return of forcibly displaced deported children, the return of Ukrainian civilians who are in the custody of Russia. All of those will be on the table. And I just want to stress the absolute importance that justice continue to have viability in that scenario. And that just requires a tremendous amount of strategizing as to how that takes place in a negotiating environment.
Thank you. Professor Crane?
Yes, and I don't mean to be jumping in all the time. It's just that I've actually dealt with these issue of political influence and stability of a court location, and I think it's important just for our general discussion as we move forward in trying to figure out those influences. Within the statute of the UN Special Court for Sierra Leone, it said very clearly that the prosecutor would not seek any advice from any other outside influence. So it's unethical anyway in any of our state bar or international bar association, is that a prosecutor cannot seek counsel from any nation and be influenced by any nation related to that. So, that from a legal point of view is kind of a given, but the practical aspect of this is, and I think Mark Ellis brought this up, is that we've got a nation that can blow away a court. Literally, figuratively. When I was in Sierra Leone, right at the scene of the crime, the main perpetrator was literally in a country just a couple hundred miles from the headquarters of the court. And that was a threat, but it was a threat that we could deal with. In a situation where we have a nuclear power that is his head of state is being investigated and potentially indicted at a minimum, and certainly prosecuted maybe eventually, then this individual has his finger on the big red button and could affect the court by literally not making it go away. And not just from a nuclear point of view, but just the influence of intelligence agencies throughout Europe by Russia. They have the ability to do really some harm individually to members of the court, what have you. They could be very, very disruptive. So I think we need to be very careful on this, and in our discussions and our step-by-step methodology. And this is why I think experienced leadership in this new court has to be paramount, because they've dealt with it, they've done with this, the things to consider. One of the things that this group that I'm a member of have discussed is a secure location for this court. And it's been even mentioned that it be put in a NATO facility where it has already the built-in ability to defend itself, but also the day-to-day security of people coming and going. But security of the court, security of the evidence, security of the records that could be attacked are going to have to be carefully considered, so that individuals who are heading this court who have done this before would automatically consider all of this, because it's just part and parcel with survival. So I think that this is a real problem, actually, is that we actually have a defendant country, so to speak, that has the ability to literally eliminate the court. And we have to face that, and we have to consider that seriously, because that is something that will always be a threat. But it can be dealt with, but it has to be, as they begin to move forward practically in the creation of it, it has to be in a place where it can be defended, so to speak.
Thank you. You mentioned evidence, and one of our questions does concern evidence. In particular, the evidence that was collected and submitted to the ICC. Some of these pieces of evidence can prove the acts of aggression. Can they both be used by the ICC and the Special Tribunal on Ukraine. Ambassador Kerinevich, do you provide any exchange of evidence between the courts, or maybe you know whether there's an agreement between the ICC and potential special tribunal to this end?
Thank you so much for the question. Well, I will not maybe talk in many details as I'm not a prosecutor, and this issue deals for sure with the matter of cooperation between Ukraine's prosecutors and prosecutors of the ICC. I mean, team of the prosecutor of the ICC. So, but what is important is that, as you all know, for more than a year and a half already, the ICPA, the International Center for the Prosecution of the Crime of Aggression against Ukraine, functions in The Hague on the basis of Eurojust, in the premises of the Eurojust, on the basis of the joint investigation team with participation of 6 states, plus also the participation as observer of some other state and the International Criminal Court also. So there is a platform where Ukraine's prosecutors can share the relevant information and evidence with the ICC prosecutors. And moreover, even without this basis, I mean, they could do this within their day-to-day work on a daily basis. So again, I'm not a prosecutor, and only prosecutors are deep into those investigations. And moreover, when they are deep in those investigations, they may not make anything public due to the security and safety of the materials and evidence. But I'm sure that within the current work, both bilateral and within the ICPA platform, there are the possibilities to do that. So I think it's quite obvious. Thank you.
Thank you, Mark.
Yeah, just on that point, and again, Anton, if you can't answer this, it's fine. But I know that there has also been discussions or concerns about, in the earlier days, from the ICC, particularly from the prosecutor, as to the jurisdiction that this new special court tribunal would have. I'm just wondering whether that has been softened a bit. Is it perceived that there will be just a collaboration between the ICC and this new special tribunal, or will the ICC have primacy over anything that conflicts, or that both the tribunal and the ICC is dealing with at the same time? Is there any sense that type of tension has been lessened now, that there's a greater degree of acknowledging either cooperation, or maybe the tribunal gives up primacy to the International Criminal Court on these things?
Thank you very much, Dr. Ellis Mark. Well, as you know, of course, it was not Ukraine who could raise any concerns or tensions on this issue. Ukraine is a big proponent of ICC, and these are not only words. Yes, we ratified the Rome Statute. We are 125th state party to the Rome Statute, so the last as of now party to join. So our commitment is not only words. Our commitment are actions. So we do believe in the ICC, and we do appreciate the ICC's work, and we do hope that these 6 arrest warrants for Russian alleged criminals is only the beginning of the journey for the ICC in relation to investigation of the situation in Ukraine. But we also believe we need a special tribunal. So Ukraine was always very open-minded and really interested in having, in special tribunal, having a good level of cooperation with the ICC. So we hope that this will be possible. And from our side, there are no obstacles on this issue. So we believe that the special tribunal can effectively cooperate with the ICC. We do have some formula in our mind, but again, it's for further discussion. And we do hope that the ICC also, when the establishment of the special tribunal will be on the rails, that we would see the active and effective cooperation from it. Thank you.
Ambassador Koronevich, while I have you here, maybe you could attempt to answer the next question, which is about whether the future tribunal could refer to the UN General Assembly Resolution 3314 from 1974. I think it's about the definition of the aggression, but please, someone correct me if I'm wrong, as a legal basis for the responsibility of the military political leadership of the aggressor state.
Yes. I think it's possible.
Clear.
And it will be quite a logical thing. Moreover, as we know, Article 8b's definition of the crime of aggression is also based on this resolution, and so yeah, it's a quite a logical thing. Thank you.
Thank you. And I would kindly invite you to maybe address the next question as well, which is about how many judges will constitute the tribunal, and is there any understanding whether it will be an equal number from Ukraine and the international community?
Well, thank you for the question. I really wouldn't want us now to return to turn to mathematics, but yeah. So we do have the suggested number of judges unequal. So yeah, so all these issues are in work. And we also think how to make the work of judges and of the tribunal effective and cost within the meaning of costs also, so that, when there are not so many suspects in custody, yes, how should the tribunal act in order for it to be cost effective? So all these issues are being worked out. And yes, of course, we do have a concrete numbers and understanding how many should be enough. Thank you.
Thank you, Professor Crane. You're muted, Professor Crane.
Thank you. Just to further Ambassador Kornevich's just comments, and of course, this is a negotiable kind of thing that is being done, obviously. But an example of that, the UN Special Court for Sierra Leone, we had, because it was a hybrid international court, we had both judges from Sierra Leone, or nominated judges from Sierra Leone on the court, as well as international judges. We had 2 trial chambers made up of international judges and a Sierra Leonean nominated judge. And on our appellate chamber, there was one appellate chamber of 5 judges. There were 2 Sierra Leonean nominated or Sierra Leonean judges in that chamber. So that's just an example of what it could look like, and one that works. The key is, though, and just to digress slightly, the Achilles heel of international criminal law are its judges. I think we're in a better place than we were back in when we were first creating many of these courts. Judges who had never been in a courtroom, judges who had only been nominated almost from a diplomatic point of view, who were dangerous in the court, to the point of where I always had assigned in the courtroom a senior lawyer monitoring the conduct of the judges, because if the judges make an error at the trial level, then it is potentially prejudicial, and you could have your case thrown out. I think we're in a better place now, as we've gone now 25, 30 years down the road. But the key is that when we are nominating judges, that the judges should have been, the international judges should have been international judges before, and not someone who has been nominated by a country just for diplomatic purposes, who has no idea what they're doing. And I think everybody on this panel can understand how dangerous it is to have ineffective judges, or judges that have no experience. So I really want to stress, fortunately, we do have now a group of jurists who could be very good at being an international judge on the court. But you have to be very, 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 very careful.
Thank you. Kirsty, please go ahead.
Well, I completely agree with what Professor Crane was saying, and can say, as I'm sure many on the panel will remember, it is exhausting being in front of inefficient and inexperienced judges. But I just wanted to mention or warn the the challenge maybe of having a kind of relatively equal split is borne out in the ECCC, the Cambodia Tribunal, where there was a very stark political rift between the judges and at the prosecutor level, just because of political differences. And I just wonder, I don't anticipate that would be the same issue for the Ukrainians, but it's always possible. So I think that it's while it can work well, I think it has to be done carefully for all the reasons that Professor Crane was outlining.
Thank you. Professor Kotler?
Yes, we've spoken about the establishment of an international tribunal as a moral and legal and international imperative, and the related importance of political will in this regard, of nationalizing political will. I have two concerns here, among others. I mentioned them in my opening remarks, but the two that I want to mention now is that President Trump has signed an executive order, to sanction the ICC and its officials. That puts the headwinds the other way, and I think we've got to bear in mind that because the U.S. is an important player here, and from establishing that political, moral, and legal and international imperative. So that's the first thing. The second is, as we know that Canada is now chairing the G7. We speak about Canada hosting the meeting in June in Alberta, but it assumed the chair of the G7 at the beginning of January. And I've met with the Canadian Prime Minister and the Foreign Minister, and have asked them to put the question of support for this international tribunal on the agenda of the G7 as a matter of principle and policy. I haven't yet seen that responsiveness to doing that, and I'm wondering whether some of the headwinds, the international headwinds that we have seen, not only with regard to President Trump, but also with regard to the international arrest warrants that the ICC issued with respect to the Israeli Prime Minister and Defense Minister, whether that too may be contributing somewhat to the adverse atmospherics. So I think it's important that we mobilize the political will internationally, and I'm still seeking to see that it's put on the G7 agenda. But I do believe that we should not discount the negative headwinds that are going to be flowing from Trump's administration.
Thank you very much, Professor Kotler. Ambassador Carell, I'm sorry.
Thank you very much. Just wanted to inform you about the question of the national nominated judges of the Special Court of Sierra Leone. Because it's important to notice that David Crane talked about nominated, and I remember that in the first nomination by Sierra Leone, one of the persons nominated was not a Sierra Leonean. He came from another country, so that is very important. Then there were references to the special court chambers in the courts of Cambodia. And I can tell you that Kofi Annan and I were very worried about the requests that Cambodia put forward in the negotiations. And as a matter of fact, we withdrew from the negotiations at a certain point in time. But we were forced back by the General Assembly in a resolution in December 2002. And I remember that this was a very complex issue, and I have written about this, and I have suggested that the special chambers of the Court of Cambodia should not be used as a model for anything similar in the future. Definitely not. And I'm now speaking as a former judge in my own country. Then when we come to the US and Donald Trump and the attacks against the ICC, I think it's unforgivable, absolutely unforgivable. And we must do everything we can to support the ICC. Thank you.
Thank you very much. Can Can you talk about the role that reparations may play in the justice process in addition to the problems around enforcement? Who would like to start on this very tricky one? A difficult one. Ambassador Karanevich, is there something in particular around this discussion that concerns reparations, or is it something that we're not ready to discuss at this point?
Yeah, thank you very much for this question. Of course, it is important. I would only mention that, of course, I mean, within the work on this issue, the matter of reparations arises, and again, quite naturally. In our work and in the work of Ukraine's government, Ukraine's leadership, and in general in the work in relation to restoration of justice, we do split two topics. Ensuring accountability for the crime of aggression by means of establishment of the special tribunal, and anything which relates to reparations and compensations for the international compensation mechanism, which, as you know, should comprise three elements. The first element exists already, the register of damage. The work on the second element is being now in progress, claims commission, and the third element, compensation fund. So everything which relates to compensations and reparations goes to that direction. So yes, it is ideologically the same work on ensuring accountability, but legally and technically this is a different track.
Thank you very much. What would be the next question? What would be the ideal BETNA/result? What would be an ideal result that you would like to achieve with the tribunal? Ambassador Karanevich, this is, I think the question is addressed to you as well.
You know, I think they say that diplomacy is the art of what is possible. With this said, I think that there may be no ideal tribunal. And this is not only about the Special Tribunal for the crime of aggression against Ukraine. I think that this is something what we see in our everyday life with the matter which honorable professors and excellencies just discussed. You may have even the strongest possible basis for the tribunal to come, multilateral treaty, yes, the best possible solution, but you will then have again challenges which raise from this very issue of the basis of the establishment. So I think that with this said, there may be no ideal solution, but the solution should be good enough, should be effective, should be feasible, should be workable, and should do the job. So this is what I think is doable, and this is what we are trying to do. And I think that if the tribunal will have a sound legal basis, if it would have strong international support, if it would have strong inter-regional support from different regions of the world, if it will have strong cooperation regime, I think that this will be a result which we all are trying to achieve. Again, we are not talking about ideal things. We are talking about the things which are possible and which will be legally solid.
Thank you. Professor Crane, you're muted.
Let me just follow on with just the discussion that Ambassador Karanevich was just talking about. You know, the individuals that are on this panel helped create all four of the major tribunals. And one of the things that I think are really important, courts and tribunals are not creatures of legal decisions. Courts and tribunals are creatures of political decisions. It's a political decision to create a court, not a legal one. The law is part of it, but the law is, it has to be, it's a political decision. And so Anton brings up a very, very important point, is that when we start out negotiating X, and we get to why it's not, it's different, but because parties come together, they have their own approaches. And so we have to come together in a way that all parties are comfortable with the end result. It's not exactly the way we initially planned it, but I think it's really, really critical. And that's what's been going on for almost 3 years now, is the very same thing. And that is political discussions on how best do we, in fact, hold accountable the Russian Federation and others for their aggression against Ukraine. It's a political decision, and that political decision, that final political decision, looks like it's going to be made hopefully in the spring of 2025. The question was, what's our goal here? Well, the goal is, and it's for and about the victims of atrocity, and that is to seek justice for the people of Ukraine, period. That is the goal. Now, there are methods that happen that way. I think from a practical point of view, though, one of the goals of the Special Tribunal is, at a minimum, that we indict Vladimir Putin for his aggression against Ukraine. Now, whether we actually prosecute him on that remains to be seen at maybe a subsequent time, but we have to hold Vladimir Putin accountable for his aggression against Ukraine. You know, there are a dozen other dictators and thugs around the world watching like crocodiles, circling in the water with their eyes just above the water, watching as to what we do. But if we can, at a minimum, indict Vladimir Putin for the crime of aggression, that sends a huge signal around the world that you will be held accountable if you invade the sovereign territory of another country.
Thank you. Professor Kotler, would you like to contribute, or is this an old hand?
No, it's an old hand.
Okay, thank you. Kirsty, then, please go ahead.
No, I was just going to add to that I think that there is a sort of higher, beyond the obvious concerns about the victims of the war and holding specifically Putin to account. I think there's a danger that if we don't enforce the law of against aggression, the use of aggression, then this principle in law might disappear. And I think that there are a lot of core principles of international humanitarian law that are really under great threat, simply by virtue of being, in a way, granted license by ongoing impunity. So I think there is also a sort of there's a huge need for the international community to preserve this as a principle.
Thank you very much. Maybe this is the question to everyone. Would a decision on a countermeasure as provided for by customary international law, for example, confiscation of frozen Russian public assets, affect the procedure in the special tribunal? And if yes, how? Anyone?
If I may just try to answer. So first of all, of course, we need to understand that countermeasures are not possible here when we talk about special tribunal, because countermeasures do not work in relation to individual criminal accountability. So countermeasures cannot be part of anything which relates to the establishment of the special tribunal because of the nature of the question, individual criminal accountability. But of course, when it relates to sovereign assets, of course, countermeasures is one of the key principles there. But I would maybe, so while saying that it has not so much to do with the special tribunal, I would revert your question vice versa, saying that special tribunal can do a lot of good things in relation to Russian sovereign assets confiscation. Because, for instance, special tribunal can say that Russian Federation committed aggression, and this would be legal denomination, which may influence the decisions on confiscation. Or, for instance, special tribunal may issue a decision, a judgment that the Russian aggression started in 2014 and not in 2022. And again, this might be a trigger point for the issues which relate to Russian sovereign assets. So I would reverse the question and say that tribunal's action in relation to defining the aggression and anything in relation to this point may be very important for other issues inside this accountability track, in particular for the issue of confiscation of Russian sovereign assets.
Thank you very much. Professor Crane? Muted.
Built within the statute of the Special Court for Sierra Leone dealing with properties and stuff, we had the ability that one of the sentences was not just incarceration but also fines and forfeiture, of which the individuals could be held accountable for as well. So that riffing off Ambassador Kornevich's point, I agree. I think the court will be a plus and a creator of revenues if necessary, if we also fine and create forfeitures of personal assets or public assets related to the crime of aggression. So that was already built in as a sentence for the judges to pass, would be not only incarceration but also fines and forfeiture.
Thank you. I also see one question that I don't think we discussed, and this is what would be the concrete consequences for Russia of a conviction in absentia. Who would like to venture this question?
I raised that question. I don't have an answer other than to say that I would support, both for practical reasons and legal reasons, for trials in absentia to occur. But I wonder, Anton, whether that too has been discussed within. Is that being mentioned in the statute specifically as to the tribunal being able to pursue trials in absentia, which I assume that's the only. If we're going to have any actions from the tribunal, it's going to be through these types of trials. But I'm just curious whether or not that has there been any development on that.
Ambassador Kornevich?
Thank you very much, Mark. Well, of course, this question is in the loop. And of course, this question is one of the key ones. Ukraine's position is solid and strong. We do believe that the tribunal should be able to have full in absentia trials. We understand the international law concerns. We understand cautious positions. We understand human rights issues, fair trial rights issues, but we also do believe that international law does not forbid trials in absentia. And we do believe that with due taking into account human rights standards, fair trial rights, and with a right to retrial when the accused comes before the tribunal, him or herself, we think that full trials in absentia should be possible.
Thank you. Ambassador Correll, you had your hand up. Would you still like to say something, or was it addressed already?
Yes, it was addressed. I mean, it's a very complex question with trial in absentia. And since I'm not sort of, I don't know the details in the discussions here, but I'm very hesitant with respect to that. But of course, if there would be such a trial, once the suspect or the person convicted then is brought accepted to serve a sentence and so forth, then I'm sure that you would have to have a trial again so that the person can present the case before the court. Thank you.
Thank you. Ambassador Scheffer, please go ahead.
Yes, I embrace all that my colleagues have just said on this issue of in absentia, to address it very cautiously. But if there were to be proceedings of some character before the special tribunal, perhaps even a proceeding that falls a bit short of literally an in absentia judgment against the individual, something similar to what we worked on, for the Yugoslav Tribunal, Rule 61. I would want to just note that if that process, if some process of that character could take place at the special tribunal, it could have a ripple effect in other jurisdictions. In other words, increasing the pressure on the defendants who are absent, but nonetheless could stir universal jurisdiction cases in various jurisdictions, and of course increase tremendously the political pressure and also the reputational damage of the defendant as a consequence of those types of proceedings. So I think that's an area where some innovative thinking is still to be considered with respect to how far the special tribunal can go to kind of get the evidence out there and at least achieve some objective prior to actual trial, with custody of the defendant.
Thank you very much, Professor Crane.
Trials in absentia are not perfect, just like any trial, any court is not perfect. But just to follow on with Ambassador Sheffer, if we had trials in absentia, and this would be a major court in a major case, if we had trials in absentia up to conviction, it would be a huge deterrent to other authoritarianism and dictators and thugs around the world watching, going, my God, I could be held liable even if I'm not even there, because that's something that they kind of hide behind, saying, well, come get me. But at the end of the day, if we start going down this in absentia road in certain cases, such as high-level state-sponsored aggression, where we have to, and the practical reality of it is we probably won't get the person who actually started the aggression. But if we have the ability in absentia to hold them accountable, I think the deterrent factor is enough that counterweights some of all of our kind of hesitation from a legal and moral point of view of trying people in absentia. So deterrence might be the counterweight to our concern, is that others, those crocodiles floating around in that river, could really raise their eyes, going, "Holy cow! This, I could actually be held liable even if I'm not there."
Thank you very much. I would like to read one more question from the chat, and this is also the last call for questions. Following an initial decision, what appeals would be possible with which delay to obtain a final enforceable decision? Ambassador Koronevich, is this something you would like to talk about at this stage?
Just maybe a general remark that, of course, while we are drafting the draft statute, we are working on all the trials section, which of course includes appeals and the formation of appeals chamber, of course. But I don't think that we should get into the details now on how this should be done. But the structure of the tribunal and the nature of the activity of both pretrial judges and trial chambers and appeals chamber, they should be quite the same as in other international courts and tribunals. So we are not reinventing the wheel. We are using the best standards which international criminal law now gives us in relation to trials in international courts and tribunals.
Thank you very much. Now, it's been 2 hours. By the book, we're ready to close to wrap up the discussion. I think I would like to invite our speakers for any final remarks that you may have at this point. If not, I would like to once again thank Ambassador Koronevich, first of all, for your time, but also for discussing these questions at this preparatory stage. And I hope that today's discussion was at least a little bit helpful in the process of the establishment of the tribunal. And I also would like to thank all our distinguished experts who shared their knowledge and expertise with us. This is a very good opportunity to contribute to the process, and I'm glad that we were a little part of it. This event was recorded, so if you would like to revisit it again, please visit our social media pages of the Ukrainian Bar Association, and while you're there, subscribe to follow our activities. I would like to wish you all a safe, good evening or the rest of the day, and we stay in touch and look forward to hear more news about the tribunal. Thank you and bye-bye.
Thank you, Ina.
Thank you.
Thank you.
Thank you. Goodbye, colleagues.
Thank you. Goodbye.